Hello, everyone, and welcome to the Ethics is Cool podcast. I swear every single time I want to say that name, it makes me giggle. And I know I start every interview by saying that, but I feel like I'm the only one who thinks ethics is cool. I doubt that I am the only one today when we're going to have our conversation with Tom Farrell. But today's podcast is brought to you by me and my book, How to Stop Hating the Law, A Path to Hope for Miserable Lawyers. I self-published an ebook that helps lawyers how to stop hating the law. It's pretty much what the title says that it is. And I've tried to make a bit of an attempt to go through every single bar counsel or chief disciplinary counsel from all 50 states. And today we're here with Tom Farrell. So Tom, maybe you want to introduce yourself. Thank you so much for being here.
Oh, you're welcome. Thank you, Stuart, for having me. I'm the Chief Disciplinary Counsel in Pennsylvania. That I work for the Disciplinary Board of Pennsylvania. I'm in charge of the enforcement arm of the Disciplinary Board. We're the entity that receives complaints about lawyers, investigates them, and then if we decide there's merit to the complaint, we prosecute them before first hearing committees. Then the case goes to the board. And if it's a case which involves either a suspension or disbarment, then the state Supreme Court considers the case. We have, I think it's 34 lawyers now throughout the Commonwealth of my office.
Wow. So do you have a separate section of either the bar or wherever that deals with like a bar counsel role that sort of assists lawyers if they have questions? I think I spoke to the people in Missouri once who told me that they have two separate sections like that.
No, Pennsylvania does not have that. I think in part because we don't have what you call an integrated or mandatory bar. So there is a state bar association, the Pennsylvania Bar Association, but membership in it is voluntary. The PBA and also the Philadelphia Bar Association often issue formal opinions on ethical issues. And Philadelphia, the PBA, and also the Allegheny County Bar Association, which is where Pittsburgh is, the three biggest bar associations in the state, they do have a hotline that lawyers can call with ethical questions and get advice. Now, their answers and their opinions are not the official position of the Supreme Court or the Disciplinary Board or my office, but our philosophy has been that if a lawyer honestly seeks advice on an ethical issue and then follows that advice, even if we might disagree, it does show that the lawyer cares about doing the right thing, and we're unlikely to discipline that lawyer. He's trying.
Yeah.
So we don't need to protect the public from that kind of lawyer.
I've often talked about in my CLE programs about what I call the repulsiveness factor. And I say that the more repulsive your behavior is, the more of a chance that they're going to look into it a little bit deeper. Actually, what I say is there's more of a chance they're going to get you. But what I really mean is there's more of a chance they're going to look into it a little bit deeper. And to me, when you do that research as a lawyer who's struggling with an ethical issue, when you do that research, it I think sort of eliminates that repulsiveness factor, don't you think?
Yes, it does. I mean, the repulsiveness factor that sometimes can be a dangerous issue because regulators and judges tend to look at people like them and think that, well, if the person's like me of a similar background, can't be a repulsive person. And as you know, we're not supposed to be punishing people. We're supposed to be protecting the public. So that leads into another problem, which is sometimes we have lawyers who are not repulsive, who in fact might be completely blameless, but are unable to represent clients competently, sometimes get into quite serious problems because they have mental health issues. Or another issue that's starting to worry us greatly is with the aging of the bar. We sometimes have lawyers who are in serious cognitive decline, maybe even dementia, who commit misconduct that really imperils clients. And we all feel sorry for them, but we may have to try to pull that person's license.
Yeah, yeah. You mentioned the opinions from the Pennsylvania Bar, Philadelphia, Allegheny, things like that. What type of weight do you give to ABA opinions? I always wondered. I hadn't planned on asking you about that, but it's always something that I wonder because they're obviously not binding, and sometimes they even conflict with local jurisdictions. I'm just curious. Any feeling about the ABA opinions?
Sort of. First of all, the same thing. If a lawyer's researching ABA opinions, then the lawyer's trying. But you're right, and there are a number. One recent issue on which, there are two I can think of where the Pennsylvania Bar Association has taken a position contrary to the American Bar Association. One is, who is at fault when a lawyer sends out an email and copies his client, and then the opposing counsel replies all, and so has you may say, an unauthorized communication with the represented party. I'll tell you offhand, I don't remember which came out which, but one of the Bar Association said, well, that's misconduct by the lawyer who sent it initially and put his client as a CC, and the other Bar Association said, no, that might be misconduct by the responding lawyer who replies all. Another more important issue is the ABA recently, within the past year, issued a formal opinion saying that flat, non-refundable fees under no condition are permissible under mostly rules 1.5 and 1.15. The Pennsylvania Bar Association in Philly issued an opinion and said, no. In Pennsylvania, they are permissible if you word your fee agreement right, so the client knows what he or she's getting into. If you use the magic words, this fee is non-refundable and earned upon receipt. Then the client has consented, given informed consent to that. We looked into the issue, and I wrote an article for a newsletter saying, well, we side with the PBA because they're in adopting 1.15 and 1.5, our Supreme Court altered the language a little bit. And I think significantly acknowledging that flat earned upon receipt fees are permissible under some circumstances.
I love the fact that you brought that up for a couple of reasons. First of all, I am a super ethics geek, and this kind of stuff, I cannot get enough of it. I don't know why I like this topic so much. I don't think it's normal, but I do. And the other thing is, I'm actually giving a CLE program next week on that opinion, on Opinion 505. I'm so glad that you mentioned to me about the Philly opinion and your article, because I'm going to make sure I look at it now. But my biggest issue was how jurisdictions... What bothers me the most about that opinion from the ABA's point of view is that they didn't come straight out and say, they didn't come straight out and address the big issue. Can you have a fixed fee paid in advance that's deemed earned upon receipt? You've got to read that opinion and figure out that that's where they're going with it. And I think that should have been in both the preamble, the little italicized part they put on the top, and in the conclusion. And I didn't know about Pennsylvania, but I did know Florida, for example, says takes what apparently now is the Pennsylvania position, which is, you can have earned upon receipt in certain situations. I felt like that opinion conflated two different issues. The issue of where you put the money when you receive it, and whether you have to return it in the end. Everything, even that's something that's deemed earned upon receipt, might have to be returned in the end. Yes. It's unreasonable.
Yeah, and that's the way the PBA in Philly come out. They say, they qualify their opinion to say, look, you can do it that way, and then technically it is your money, so it need not go into your trust account. You can put it directly into your operating account. But there are circumstances under which that kind of fee might be unreasonable, even if initially it was okay, and you may be obligated to return it to the client if you don't want to be disciplined, such as you're fortunate enough that a client walks in. I was a criminal practitioner for many years, so I use that example. Client's been indicted or is about to be, usually about to be. It gives you $50,000 flat fee. You meet with the client for an hour. Then the next day, someone talks to him and says, Farrell's not the best guy for that. You should get Stewart. And the client says, and meets with you. Says, I like him better, and discharges me and retains you. Well, $50,000 for a 1 hour.
Okay, so we had a little technical glitch there. You were saying that you were giving the example of someone pays $50,000 to you, turns out that you do about an hour, they decide to go somewhere else, and you were going to talk about whether you got to refund that fee.
Yes, under the PBA position and our position, you would. Under Rule 1.5, that $50,000 for an hour sounds great, but that's an excessive fee.
Yeah.
Now, you and I probably could imagine circumstances where it might not be. For example, if the client knows and you that by meeting with you for an hour, he or she's conflicted you out of as another client in the same matter, that could have been a very lucrative fee. So it depends on the circumstances.
Right, and in that situation, what you basically do is apply Rule 1.5, and you look at the different factors, and all of those things you just discussed are included in that in that list. So that's why I think that the ABA, I don't want to make it sound as if I'm sitting up high, but I think it was poorly written. I really do. I won't ask you to say that because the position you're in, but I think it was poorly written.
Well, I won't disagree with you, and I'll also add that it really smacks of being written by big firm lawyers for big firm practitioners instead of considering the small and solos who are the ones who more often enter into these flat fee arrangements.
Well, we got off into some substance right away, which is awesome. But normally where I start, and I'll double back with you, is to ask you how you found your way into the world of the attorney disciplinary system.
Like most of the choices we make in life and most of the paths we go down, by accident. I was in... I started my career as a public defender in New York City, in Brooklyn, New York. That's where I'm from. I had clerked for a federal judge in Pittsburgh, decided to go back to Pittsburgh, ended up becoming an assistant U.S. attorney there for a number of years, and then I was in private, small firm, mainly white-collar criminal defense practice for about 20 years. It was good work, exciting work, interesting work, did a lot of high-profile cases, represented professional baseball players, Sammy Sosa, Andy Pettit, before Congress in the steroids investigations, then ended up representing one of the Penn State administrators who was charged with covering up allegedly what Jerry Sandusky had done there. At the end of that case, which was a really exciting but draining case, I was ready to leave private practice. I wanted to, frankly, get back into public service for at the end of my career. And I was considering applying to become the public defender, the chief public defender in Allegheny County. And I asked a friend, one of the justices on the Pennsylvania Supreme Court, to recommend me for the job, and she says, "Sure, but I have a better job for you. Our Chief Disciplinary Counsel is retiring. How about you apply for that?" So I did, and it fit because I won't go into all the gory details. We've already been geeky enough, as you say, of the Penn State case, but there were a lot of significant ethical issues, conflicts issues, confidentiality issues that actually we won and ended up in resulting in the dismissal of some of the most serious charges in the case. So I had been looking at and starting to speak and write about ethical issues toward the end of my time in private practice anyway. So I thought it'd be an interesting and rewarding thing to do, and it has been. So I started in this job January of 2020, which means for the first year I was a public health official because of the pandemic. But that too was interesting in its way.
Well, how did you end up becoming? I mean, I know what you're being sort of facetious with the public health official, but what was that angle? How did that angle fit into your work in the disciplinary office?
Well, we had to make decisions about how we would work with and how we would protect our employees. And at the time the pandemic started, the whole Pennsylvania judicial system, which includes not only our office but all 67 counties, was able to accommodate, I think it was only 30-something people on remote video access or VPN into their system at one time. So it was able to get up to speed, and we quickly instituted remote work for all our employees. Then quickly remote disciplinary hearings, so that we were able to continue working with hardly a glitch, and it went very smoothly.
Are you still doing the hearings online?
Yes, we did hearings online, arguments online. The Supreme Court did oral arguments online too. We've gone back to in person, but we still use remote hearings for a number of issues. Frankly, I think it improves the access to justice. As you know, having done this work, a lot of respondent attorneys sometimes don't have much funds, and Pennsylvania's a pretty big state. So the attorney and his witnesses might be pretty remote from where our hearing areas are. So we allow them to participate remotely if they want to, have witnesses testify remotely. And unfortunately, we've had a couple of cases where the attorneys have threatened our staff with violence, and we do those remotely as well.
Yeah, it's good that they're not in the same room at that point.
Exactly.
Yeah. In New Jersey, we're still doing them online. I heard that they started to do some, and what I heard was that the biggest reason was with all of the backlog of the court cases, they didn't have any courtrooms available for us to use at that time. I heard that they're started to go back to do some of them live. All the ones that I've been participating in have been online still. I'm torn about it because I definitely see the access to justice issues. We're not quite as large as Pennsylvania, so we don't have necessarily the same, and we're divided by county, so it's not necessarily the same remoteness issue. The only thing that I'm concerned about is whether both parties are able to really assess the credibility of witnesses and stuff like that. You know, when it comes to the respondent lawyer coming in to defend themselves, you want them to be able to appear as credible as possible. And but on the other hand, these systems have come a long way, and you can assess it in this way. It's not like we're looking at one of those CCTV screens from the old days, So I kind of go back and forth about it personally.
Yeah. No, there are advantages to being there in person, but as you say, the technology's improved. Yeah. We've become more comfortable with it, and even as today shows, when there are glitches, even old timers like me are able to work around them.
Yeah. So what was maybe the one thing that surprised you most about the disciplinary system, having been in it for, I don't know, it's been 4 years now already?
The two things. One thing about the system is really how opaque it is. Mm-hmm. We have confidentiality in our investigations, and we still have the lower levels of discipline are private. But it's not that. It's that the procedural rules are a complete mystery to most lawyers. I give a lot of CLEs where the gist of the presentation is simply to explain the way this process works. And lawyers are fascinated because this is news to them. Before I took this job, I was doing pretty complex, high-level litigation, and I was a volunteer hearing committee member for the disciplinary board for 6 years. Still, I was gobsmacked by how arcane and unknown our procedures were. So that's one thing. The second issue, more substantive. Look, as I told you, most of my career I was a prosecutor or a criminal defense lawyer. I've defended mainly fraud cases, public corruption cases, prosecuted them too, but I've also defended some pretty serious death penalty cases. So I've seen a lot of, let's say, questionable behavior. But the one thing that disappoints me and has surprised me a bit about the misconduct I've seen is lawyers forget, it seems, that you owe a fiduciary obligation to your clients. Lawyers spend a lot of time complaining about their clients, trashing their clients, claiming that their clients have lied about them, when we have a trail of emails and text messages showing this is not the case. We find lawyers trying to, frankly, exploit their clients, name themselves in wills, enter into business dealings with clients, and of course, the high-profile misconduct have sexual relationships with their clients, often documented in email and text message, and fee disputes, and especially coming from a background where I defended people who were charged with pretty reprehensible things. My position was always, hey, look, if you wanted people to be grateful to you, you should have become an undertaker, or no one complains there, or you should become a veterinarian. People love their pets, and they're always very happy when you can help their pets. But you're representing people at a crisis point in their life. Their interests come first, and you should not, as soon as things go bad, refuse to give them the file or claim they misbehaved and offer to testify against them. As perhaps you detect, I get pretty passionate about this. This really upsets me. And now, the number of disciplinary matters is a very small percentage of the number of lawyers, and certainly the number of transactions lawyers have with clients. But still, that's disappointed and to some extent surprised me.
I understand why you feel that passionate about it, even if it's a minority, small number. And when I teach my students I teach at Georgetown Law. I've been there for about 10 years. I've been an adjunct teaching professional responsibility. And when I teach my students about it, or when I teach CLE programs, I say that one of the things that threads through the rules is how lawyers have a heightened sense of responsibility when it comes to people in vulnerable positions. And when you look at Rule 1.8, which is the rule that deals with specific conflicts of interest, as you know, the one thing that ties all those specific conflicts of interest together are the fact that they're all about conflicts between lawyer and client. And those situations, the rule doesn't replace 1.7, it adds to Rule 1.7. And the reason is because the drafters realized that those situations are the most dangerous situations in the practice, where you pit your own interest up against that of your client. And when you mentioned about contingencies too, it's pretty much the same thing. It's a conflict between lawyer and client. And I get it about why that would really get under your skin, because here you've got clients who are in vulnerable situations. They're scared. They're spending a lot of money. They've got very big ramifications. And the person that's supposed to be the one person, as they say in A Few Good Men, standing on the wall for you, that's the person that starts to take advantage of you, and it's just wrong.
Yes. Yeah,
I get it. So that kind of maybe feeds into the next question that I have, and I'm curious to know what your answer to this is, because I have a feeling also. What do you think the quickest way is for a lawyer to get involved in a bad way in the disciplinary system? Like not necessarily the surest way, but what do you think? I don't know, the quickest way. Let's leave it at that. What do you think?
So when you say quickest,
Sure, the most. I don't know. You take it for whatever you will. What's your answer?
So quickest. I'll take it this way. The most likely to get caught.
Yeah.
I mean, obviously we all know that the way to get yourself suspended or disbarred, even if it's your first offense, is to outright steal your client's money.
Right.
I don't know if that's the quickest way to get caught, because so long as your trust account doesn't go negative, it's not going to get reported. And if you're playing a Ponzi scheme, sort of, where you're borrowing and covering it with another client's money, maybe even putting your own money in, then you might not get caught for a while. I think that the quickest way to get caught and get yourself serious discipline is to lie in litigation. And that because it will be noticed by the opposing party, certainly by the judge, and we take lying very seriously. And I also mention that because it relates to something I've noticed about how lawyers really hurt themselves unnecessarily. They don't own up to their mistakes. You miss a deadline, you fail to respond to a discovery request, miss a statute of limitations. That's bad, and there may be a disciplinary complaint. You own up to it, it's probably not going to be serious discipline. But you lie to cover it up, now you're going to get suspended.
I think I'm going to change my answer going forward. I like yours. The quickest way to get in is to lie in litigation, because of all the other people who are there that see it and both want to and have a duty to report you. What I used to say before that, and I let my New Jersey out here a little bit. I used to say that the quickest way to get into the disciplinary system is to piss off your client. Whether it's to not give them their money back promptly, or not communicate, or something you mentioned before, which always never stops baffling me, when a lawyer does not return the file at the end of the thing. I mean, that makes them so angry. So angry.
Yes.
Well, I know you have a busy day, so I just have two more questions for you. I don't want to keep you all day long. My one question is, have you seen anything with generative AI in your work yet? I mean, everyone's talking about it, and there are all kinds of opinions coming out. Just wondering if you've had any exposure to it in the disciplinary world.
Not in a disciplinary case. It's something we're monitoring. We have a quarterly board meeting, and actually the next educational session, October's meeting is always an educational session for the board. We're going to have someone come in and speak to the board and to us about the ethical issues that swirl around the use of generative AI. So we're not seeing cases yet. The aspect that really intrigues me, the cases that we've seen so far, they're obvious. It makes up fake cases. You don't even check it. It's like hiring someone off the street to write you a brief, and you don't even check the cases.
Right.
But the interesting issue is, I think this really can be change the nature of legal practice, so that it enables small firm practitioners better to compete with big firms, and also enables lawyers to do things a lot more quickly and efficiently. Now, that raises problems about, do we need young lawyers if their work can be replaced with it? But it also raises the questions of whether in the future the obligation, the duty of competence, requires that attorneys know how to use this stuff, because it can be such a powerful tool.
Yeah, I've often told lawyers that when it comes to the duty of competence, it's a question of we know our duty of competence evolves as new technologies become integrated with the practice. The hard part is identifying when they're deemed integrated with the practice. It feels like that with generative AI, everyone is pretty much saying, don't use it so much yet for certain things because there's a lot of things, and I don't know that it's considered integrated yet, but it's we're I feel like we're sitting right inside a paradigm shift.
Yes, I agree with you.
Yeah.
And you're right. We have to be careful. I read an article recently that tested a number of the programs. Obviously, the one that's had drawn the most publicity is ChatGPT. But this article found that even the programs that Westlaw and Lexis market now, whatever they call them, co-counsel, whatever, in a substantial number of cases, their programs generate hallucinations.
Yeah.
So we have to be careful.
Yeah, exactly. And you mentioned something also about that, and this is what I think is maybe the unfortunate fallout is I think the people whose job are most at risk are new associates. Mm-hmm. Because that's what ChatGPT does. ChatGPT gives you, and I don't mean to refer just to that. I mean generative AI. That's what it does. It gives you that first pass at what you normally give to an associate to do. So it's I think what's going to end up happening is that, and it's not going to be in the very near future, but it's going to fall out between associates. There's going to be downward pressure on associate wages and the need for associates, and then law schools are going to start to feel it because less people are going to start to go there. I think, I don't know. That's just my feeling. I don't know.
I agree with you. I think we see that trend already, that the number of applications and admissions has declined. And a lot of people think it goes back to a previous form of artificial intelligence, the TAR, the technology-assisted review and discovery.
Right. So my last question to you, and then I'll let you go, is if there's one thing that you could get lawyers to stop doing, what do you think that would be? And you can't say having sex with clients. We already talked about that. And as a joke, by the way, in all my CLE programs, I tell lawyers, don't have sex with your clients and don't steal from your trust account, because even if the program's not about that, just because I want to make sure we actually get credit for the program, and I think you have to mention that. So anything else you could think of?
Actually, I saw that you asked that question, and I came up with more than one.
Good.
But I'll try to give you the prime one, something I mentioned already, and it's this. Look, practicing law is difficult, and there are going to be situations where you are going to make mistakes. Make a mistake, it happens, face up to it, disclose it, talk to your client, talk to the judge, disclose it, don't run away from it, and my goodness, don't try to cover it up, because then you're making a serious disciplinary matter of it. So I'll add the others, but that's the main one. Face up to your mistakes, be honest about them. People will give you credit for being brave in that way. The second, read the rules. I mean, so many times we have attorneys who, for example, fail to reconcile their trust account. I didn't know I had to do that. Well, it's right in the rule. Read the rules. Third, be careful about doing favors for people, especially unpaid favors, because that uncontested divorce for your cousin, it may turn out to be contested. 2 years from now, you're ignoring his calls, and now you have a disciplinary matter. Number 3, along the same lines, be very careful about straying from your area of expertise. And this is kind of business advice too. If you may be a criminal defense lawyer, you think you're a great trial lawyer. Well, medical malpractice plaintiff's work, for example, is a very specialized area of law. You see big dollars. Oh, buddy, be careful. You're going to get in trouble that way. And finally, this perhaps isn't a rules of professional conduct issue, but it can lead to that kind of problem. and treat everyone with respect and courtesy. Clients, opposing counsel, witnesses, judges, your staff, court staff. When you don't, they're more likely to complain against you. And also, it just mucks up the process. Things don't work. Litigation doesn't get settled. It doesn't proceed quickly. Our system gets mucked up. Be respectful to us. Don't threaten to kill us. Please.
Don't threaten to kill bar counsel. It's a fair request.
Oh, we recently had a matter that went from informal private discipline to an emergency temporary suspension because of that.
Yeah.
Oh, that's quite a difference and quite career and life altering.
That last element about professionalism and civility, I think, is a perfect place to end. I always tell lawyers, the ethics rules establish the minimum boundaries of our behavior. But if we really want to be able to live up to our profession, we have to aspire to something higher, a little bit more than just the mandatory minimums. Tom, thank you so much for your time. It's really been a pleasure to speak with you. I really appreciate you taking your time out to talk with me today.
Oh, you're welcome, Stuart.
Thanks.
I greatly enjoyed it too.
All right, have a good one.
Have a good one. Thanks.